Over 40,000 removal orders were enforced in Canada in recent years, and immigration experts say that number could rise sharply in 2026. But here's the shocking part. Many of the people affected aren't criminals. They're students, temporary workers, even permanent residents who thought they were fully protected. What if a simple paperwork mistake, a job change, or even working a few extra hours could suddenly put your entire future in Canada at risk? This year, Canada introduced stricter enforcement rules tied to the Immigration and Refugee Protection Act, and they are changing how deportation decisions are made. Digital tracking systems, faster removals, tighter residency checks, and expanded officer powers are now reshaping the immigration landscape. And most people don't even realize how these updates could affect them. So who is really at risk in 2026? And what small mistake could trigger a big consequence? Stay with me, because some of these changes might truly surprise you. Number 1. Misrepresentation rules expanded. Recently, Canadian immigration authorities have widened the definition of misrepresentation, and this change is more serious than most people realize. In the past, misrepresentation usually meant submitting fake documents or lying about your identity. But under the updated enforcement approach in 2026, even small inconsistencies, like missing travel history, incorrect employment dates, or failing to mention a previous visa refusal, can trigger an investigation. What makes this alarming is that intention does not always matter. Even an honest mistake can now be treated as providing false information, and the penalties are severe: a possible removal order, loss of status, and a 5-year ban from reapplying. What's even more concerning is how advanced verification systems have become. Immigration officers now cross-check applications using digital entry-exit records, tax information, employer compliance data, and even past applications filed years ago. If the details do not perfectly align, it can raise red flags instantly. For example, listing a job that does not match tax records, forgetting to declare a short trip abroad, or submitting outdated supporting documents can create suspicion. Many applicants assume minor gaps will be overlooked, but in today's system, inconsistencies are easier to detect than ever before. Most importantly, you can protect yourself with preparation and transparency. Always review previous applications before submitting new ones. Keep copies of work permits, study permits, travel stamps, and employment letters. Double-check every date and spelling carefully. If you are unsure about disclosing something, it is safer to explain it clearly rather than hide it. In 2026, accuracy is not optional. It is essential for protecting your future in Canada. If this surprised you, tell us honestly, have you ever made a small mistake on an application? We work hard to bring you updates like this, so please subscribe. It takes one click but helps us continue making these important videos. Number 2. Faster removal for criminal offenses. Canada has intensified enforcement around what qualifies as serious criminality, and the impact is reaching further than many permanent residents expected. Previously, individuals with lighter sentences sometimes had broader appeal rights or more time to respond before facing removal. Now, certain offenses, even those resulting in shorter jail terms, can trigger faster deportation proceedings. This shift means that permanent resident status no longer guarantees strong protection if a criminal conviction falls within the expanded enforcement categories. The government's focus is on accelerating removals in cases tied to public safety, reducing delays in the system. Beyond that, appeal options have become more limited in specific situations. Some individuals may no longer qualify to appeal their removal order to the Immigration Appeal Division if their offense meets the updated threshold. This change significantly reduces the time available to challenge a decision. Even charges that seem minor at first, such as fraud-related offenses, assault cases, or repeated impaired driving incidents, can carry immigration consequences far beyond fines or probation. Many people separate criminal court outcomes from immigration status, but in reality, they are closely connected under the Immigration and Refugee Protection Act. Most importantly, prevention and early legal advice are critical. If you are a permanent resident facing charges, speak to both a criminal defense lawyer and an immigration lawyer before accepting any plea agreement. Understanding the immigration consequences of a conviction can make the difference between staying in Canada and losing your status. In today's stricter environment, One legal mistake can have life-changing results. Do you think permanent residents should face faster removal for certain crimes? Share your thoughts below, and if you value the effort we put into breaking down these complex updates, subscribe to the channel. It's just one click that helps us keep you informed. Number 3. Digital overstay crackdown. Today, overstaying a visa in Canada is far riskier than it was just a few years ago. The government has fully strengthened its digital entry-exit tracking system, which automatically records when travelers enter and leave the country. This means immigration authorities no longer rely only on physical stamps in your passport. Airlines, border systems, and international data-sharing agreements now work together to flag overstays almost instantly. Even remaining in Canada a short time after your visitor visa, study permit, or work permit expires can trigger automatic alerts in the system, putting you at risk of enforcement action. What makes this change more serious is the speed at which consequences can follow. In the past, some individuals applied for restoration after falling out of status and faced fewer immediate complications. Now, repeated overstays or long periods without valid status can negatively affect future applications, including work permits, permanent residency, or even temporary visas. Officers reviewing your file can clearly see gaps in your legal status history. A small delay that once seemed manageable can now appear as a compliance issue that raises questions about credibility and reliability. Most importantly, protecting yourself requires careful planning and strict attention to deadlines. Set reminders months before your permit expires. Apply for extensions early, and always keep proof of submission receipts in case your application is still being processed. If your status has already expired, act immediately to seek professional guidance about restoration options. In 2026, timing and documentation are not just administrative details. They are essential safeguards for your future in Canada. Have you ever worried about missing a visa deadline? Share your experience below. And if these updates are helping you stay prepared, subscribe to the channel. It's one simple click that supports the hard work behind every video. Number 4. Student compliance monitoring. Across Canada, international students are now under stricter compliance monitoring than ever before. In 2026, designated learning institutions are required to report updated enrollment data directly to immigration authorities, including whether a student is actively attending classes, has dropped courses, or has stopped studying altogether. This means your study permit is no longer just a document. It is tied to real-time academic reporting. If you fall below full-time status without authorization or fail to meet the conditions of your permit, it could trigger a review that may lead to loss of status or even removal proceedings. At the same time, work hour violations are being taken more seriously. While temporary policy adjustments in past years allowed extended work hours, enforcement has tightened again. Students who exceed permitted weekly work limits or work for unauthorized employers may now face compliance investigations. Many students assume that a few extra shifts will go unnoticed, but payroll records, tax filings, and employer inspections can easily expose violations. Even taking a break from studies without properly updating your status can create serious immigration consequences later when applying for a post-graduation work permit or permanent residency. Most importantly, staying compliant requires organization and awareness. Track your work hours carefully, remain enrolled full-time unless officially approved otherwise, and inform immigration authorities if you change schools or programs. Keep copies of transcripts, enrollment letters, and employment records in case questions arise. In 2026, being an international student means more than attending classes. It means actively protecting your immigration status through careful compliance. Are student work limits too strict, or are they necessary? Tell us what you think below. And if these insights help you stay informed, subscribe to the channel. It's one click that supports the effort we put into every update. Number 5. Work permit violations tightened. In 2026, enforcement around work permit conditions has become significantly stricter, especially for those holding employer-specific or closed work permits. These permits clearly state who you can work for, where you can work, and sometimes even what position you can hold. Changing employers without proper authorization, even if the new job seems similar, is now treated as a direct violation of your status. Immigration authorities are increasing workplace inspections, and employers are required to maintain accurate records, making it much easier to detect unauthorized employment. At the same time, compliance checks are becoming more detailed and technology-driven. Payroll records, tax filings, and employer compliance reports are cross-referenced with your permit conditions. If your permit lists one employer but your tax slips show income from another company, that inconsistency can immediately raise red flags. Some workers assume that short-term contract work, remote side jobs, or cash arrangements will not be discovered, but digital reporting systems make these activities far more visible than before. Even misunderstanding your job title or location restrictions could create complications during future applications for permanent residency. Most importantly, protecting yourself means reading your permit carefully and acting before making changes. If you want to switch jobs, apply for a new work permit, or use approved pathways that allow job mobility before starting the new role. Keep written employment contracts and copies of all approvals. In 2026, flexibility without authorization can cost you your legal status, so every career move must be planned strategically. Have you ever considered switching employers while on a closed work permit? Share your thoughts below. And if this breakdown helps you avoid costly mistakes, subscribe to the channel. It's just one click that supports the effort behind every video. Number 6. Refugee Claim Fast-Track Decisions. Canada has introduced faster processing timelines for certain refugee claims, and this change is reshaping how protection cases are handled. Authorities are aiming to reduce backlogs and make quicker decisions, especially for claims coming from countries considered relatively stable. While faster decisions may sound efficient, they also mean less time for applicants to prepare strong documentation. A claim that once had months for evidence gathering may now move forward in a much shorter window, increasing pressure on individuals who are already in vulnerable situations. At the same time, claims identified as lower risk or coming from designated safe regions may face accelerated review procedures. If a case is rejected under these faster tracks, removal orders can follow more quickly than before. Appeal timelines are also tighter, leaving little room for delays or incomplete submissions. Many applicants assume they will have plenty of time to gather medical reports, police documents, or witness statements, but under the new system, delays can significantly weaken a case. Even small inconsistencies in testimony can now carry heavier consequences because officers are working within stricter efficiency targets. Most importantly, preparation and legal guidance are more critical than ever. Refugee claimants should seek experienced legal representation as early as possible, organize all supporting documents immediately, and ensure their personal statements are detailed and consistent. Waiting until the last minute can jeopardize the entire claim. In 2026, speed is a defining factor in refugee decisions, and readiness can make the difference between protection and removal. Do you think faster refugee decisions are fair or risky? Share your perspective below, and if you appreciate the depth we bring to these updates, subscribe to the channel. One click helps us continue creating valuable content for you. Number 7. PR Residency Enforcement. In 2026, Canada tightened enforcement of the permanent residency obligation, and many PR holders are only now realizing how strict the monitoring has become. To maintain status, permanent residents must be physically present in Canada for at least 730 days within a 5-year period. While this rule has existed for years, what has changed is how closely it is now verified. Digital entry and exit records are automatically matched against PR card renewal applications, making it far easier for officers to detect time spent outside the country. Even small calculation mistakes can now trigger deeper reviews. At the same time, PR card renewals are facing more detailed scrutiny. Officers may request additional documents such as tax filings, employment records, lease agreements, school enrollment letters, or utility bills to confirm actual residence in Canada. Some permanent residents previously relied on rough estimates of travel dates, but in 2026, approximations are risky. If your recorded travel history shows you fell short of the required days, you could face a residency determination process that may ultimately lead to loss of PR status. Many people assume that holding a valid PR card guarantees protection, but it is the physical presence requirement that truly matters. Most importantly, permanent residents should track their travel days carefully and review their residency status every year. Keep copies of boarding passes, maintain organized travel logs, and ensure your tax filings align with your declared residence. If you are close to the minimum threshold, consider delaying extended travel plans until you safely exceed the requirement. In today's enforcement environment, proactive record-keeping is essential to protect your long-term future in Canada. Are you confident you meet the 730-day rule? Let us know in the comments. And if these insights help you stay prepared, subscribe to the channel. One simple click supports the hard work behind every update. Number 8. Expanded border officer powers. At Canadian borders in 2026, officers now have broader discretion to assess admissibility and issue enforcement actions on the spot. What used to result in secondary questioning may now escalate more quickly if inconsistencies appear in your documents, travel history, or stated purpose of entry. Border officials can access integrated databases that show prior visa applications, past overstays, employment records, and even previous refusals. If your answers do not align with the digital record, it can immediately raise concerns. In certain situations, officers can issue removal orders directly at the port of entry, especially in cases involving misrepresentation or prior status violations. Equally important is the expanded ability to review electronic devices and supporting documents when determining credibility. While not every traveler is searched, officers may examine emails, employment letters, or travel itineraries if they believe additional verification is necessary. Many individuals assume that a valid visa guarantees entry, but admission is always conditional upon satisfying the officer that you meet all requirements. Even permanent residents can face detailed questioning if residency obligations or previous compliance issues appear in the system. The border is no longer just a checkpoint. It is a real-time compliance review. Most importantly, preparation and honesty are essential. Always carry clear documentation that supports the purpose of your trip, whether it is study, work, or tourism. Answer questions directly and consistently, and never attempt to hide past issues, as digital systems often reveal them. In 2026, transparency at the border is your strongest protection against unexpected enforcement actions. Have you ever been questioned extensively at the border? Share your experience below, and if this information helps you travel smarter, subscribe to the channel. One click keeps these important updates coming. Number 9. Sponsor accountability tightened. In 2026, Canada has strengthened financial enforcement around family sponsorships, placing greater responsibility on sponsors than ever before. When you sponsor a spouse, parent, or other eligible relative, you sign a legally binding agreement promising to financially support that person for a specific period. Under the updated enforcement approach, if the sponsored individual receives certain types of social assistance during that period, authorities are moving more aggressively to recover those funds from sponsor. What many people once viewed as a routine process is now being treated with stricter financial monitoring and follow-up. At the same time, immigration systems are better connected with provincial benefit databases, making it easier to track whether sponsored individuals access public assistance. Sponsors who fail to repay outstanding amounts may face serious consequences, including being barred from sponsoring again in the future. In some cases, unresolved financial obligations can also impact the sponsor's own immigration applications or credibility in future dealings with authorities. Many families are unaware that the sponsorship undertaking continues even if relationships change or financial hardship arises, and misunderstanding this commitment can lead to long-term complications. Most importantly, anyone considering sponsorship should carefully assess their financial stability before signing the agreement. Maintain clear income records, understand the exact length of the sponsorship obligation, and seek advice if circumstances change. Sponsorship is not just an emotional commitment, it is a serious legal responsibility. In 2026, failing to meet that responsibility can have lasting immigration and financial consequences. Do you think sponsorship rules are fair or too strict? Share your opinion below, and if you value the effort behind these detailed explanations, subscribe to the channel. It's one simple click that helps us keep delivering important updates. Number 10. AI surveillance and data sharing. One of the biggest changes is something you cannot see: the expansion of artificial intelligence monitoring and international data sharing in immigration processing. Canadian authorities now use advanced risk assessment systems to analyze applications across visa, study permit, work permit, refugee, and permanent residency streams. These systems can automatically compare your current file with past applications, travel history, tax records, and even information shared by partner countries. If there are inconsistencies, different employment dates, undisclosed refusals, mismatched personal details, the system can flag your profile before an officer even begins reviewing it. At the same time, cross-border information sharing agreements have grown stronger. This means a visa refusal in another country, previous immigration violations abroad, or contradictory statements made in earlier applications may now be more visible to Canadian authorities. Many applicants assume that what happened in another country will stay there, but digital cooperation between governments has changed that reality. Inaccurate or incomplete disclosures can quickly be detected, and once credibility is questioned, it becomes much harder to rebuild trust in future applications. Most importantly, honesty and consistency are your strongest protection. Always review previous submissions before filing new ones. Disclose past refusals clearly, and correct errors proactively rather than hoping they go unnoticed. In today's digital environment, transparency is not just recommended, it is essential. The system is faster, smarter, and more connected than ever before, and preparation is your best defense. Do you think AI should play such a big role in immigration decisions? Share your thoughts below, and if these deep insights help you stay ahead, subscribe to the channel. One click supports the effort we put into every detailed update. As we step into 2026, one thing is clear: Canada's immigration system is no longer just paperwork and waiting periods. It is now faster, more digitized, and far more strictly enforced than ever before. From expanded misrepresentation rules to tighter work permit compliance, from stricter residency tracking for permanent residents to advanced AI risk assessments, the message is simple: every detail matters. Even small oversights that once seemed harmless can now lead to serious consequences, including loss of status or removal orders. What makes these changes so important is that they affect ordinary people, students chasing education, workers building careers, families reuniting with loved ones, and permanent residents planning long-term futures. Many individuals assume that once they receive a visa or PR card, their status is secure. But in today's system, compliance is ongoing. Deadlines must be tracked, employment conditions must be followed, travel days must be counted accurately, and every application must be consistent with your history. The margin for error has become much smaller. At the same time, Canada remains a country of opportunity. These stricter measures are designed to protect the integrity of the immigration system, but they also require applicants to be more informed and proactive than ever before. Staying organized, seeking professional advice when necessary, and being transparent in every interaction can make all the difference. Knowledge is no longer optional. It is your strongest safeguard. Which of these new rules concerns you the most? Tell us in the comments. We truly read them all. If this breakdown helped you, please support our work by subscribing. It's just one click, but it keeps these detailed updates coming. And don't forget to watch our previous video to stay one step ahead.